Hello and welcome to the in-depth series of Drishti IAS. My name is Pooja Dwivedi. The Jharkhand Legislative Assembly has passed two bills to be placed into the 9th schedule of the Indian Constitution. At the backdrop of it, we will talk about the bills as well as what is the 9th schedule. From the perspective of GS Mains Paper the second, it is important from the perspective of polity and governance, and preliminary facts are important. So without further ado, let us start with the different topics that we are going to cover under this segment. This is the walkthrough and we will cover it from the perspective of your examination UPSC. So let us move ahead and talk about the bills. The two bills that we are talking about today is the Jharkhand Reservation of Vacancies in Posts and Services Amendment Bill of 2022 that has raised the reservation up to 77%, not up to but to 77%. That means it breaches the 50% limit in the Indra Sawhney case, the reason for which it should be placed according to the Jharkhand Legislative Assembly in the 9th schedule. For scheduled castes, the reservation will be 12%, which is upward from earlier 10%. 27% for OBCs, upward from 14%. 28% for scheduled tribes, that is 2 percentage points moving upwards, and 10% for economically weaker section. The second one is the Jharkhand definition of local persons and for extending the consequential social, cultural and other benefits to such local persons bill of 2022. We can call this the domicile policy, which seeks 1932 to be the cut off for any person to be regarded as a local in Jharkhand. It wants to grant local residents certain rights and benefits and preferential treatment over their land. This is also known as Sons of the Soil theory. Sons of the Soil theory is the theory in which it is said that the locals should get the benefit of where they belong to. And this can cause regionalism as well. So it's not a very healthy precedent. Now, in their stake in local development of rivers, lakes and fisheries as well, in local traditions and cultural and commercial enterprises, in rights over agriculture, indebtedness and availing agricultural loans, we can see that the locals of Jharkhand basically belong to either scheduled tribes, scheduled castes, OBCs, most of them are scheduled tribes. So, as they have seen so much injustice provided to them, they were always at the receiving end of the lesser receiving end of the stick. So what happens? That they become insecure with respect to their status in Jharkhand. That is why the domicile policy, according to the sovereign government, has been brought into place. Moving ahead, let's talk about the other important points of the bill. In maintenance and protection of land records for their social security, in employment in private and public sector, and for trade and commerce in the state. Reservation that we talked about was in jobs, okay, and colleges. So now if we talk about the 9th schedule. 9th schedule is a schedule in which a list of central and state laws are there. These central and state laws cannot be challenged in the courts. So, judicial scrutiny is not available for this. This was added by the Constitution First Amendment Act of 1951, created by Article 31B, new Article 31B, along with Article 31A. This particular schedule was created in order to safeguard the rights of the lands of the tiller. Basically, to abolish zamindari, this schedule was created. So, majorly it had agrarian laws which were protected from the judicial scrutiny. And it contained originally 13 laws. Now it has risen to 284. So many classes of laws apart from the agricultural laws are also included here. Now Article 31A, while wants to protect a class of laws, there are different classes of laws which are protected, but Article 31B is much more specific because it states which particular laws and acts will be, it gets protection from the judicial scrutiny. Also, Article 31B is in retrospective operation. That means if any law has come into force from a back date and in any course of time it is said to be invalid, Article 31B can protect that law from becoming invalid as it was included from a back date. Okay. Then it also excludes, Article 31B excludes judicial review. But the judicial review can come into place if the acts violate fundamental rights or the basic structure of the Constitution, in which we will also discuss the basic structure. Now, the current need of the bill was such that the current need of the bill to be included in the 9th schedule is such because it is providing 77% reservation, which breaches the 50% ceiling according to the Indira Sohni case of 1992. But recently, as economically weaker section of that is being provided to the EWS, it also breached the 50% limit because it provides 10% of reservation to the EWS. It was also upheld by the courts. So there is a current takeaway from this particular move. Although it has been given a nod by the Jharkhand Legislative Assembly, it is still not included as of yet in the 9th schedule because it is the duty of the center. It's basically center's responsibility to find a way to include this in the 9th schedule of the constitution. The sovereign government says that if it would be possible for the center to find a way, then it's fine. If not, then they will go to Delhi to talk to the center, as it happened before as well. Now, there are certain controversies with respect to the domicile policy as well. Provisions which were formulated by the BJP government in 2016 said that people living in Jharkhand to be called as locals should be the ones who were there since before 1985. But Jharkhand Mukti Morcha led alliance, which is the current sovereign government, when it came into power in 2019, it said that we do not want 1985 to be the cutoff, but actually 1932 should be the cutoff. Now, as per the proposed domicile policy, the current one, the bill, people who have their names or their ancestors' name reflected in the 1932 land records, they will be termed as locals. If any person does not have any land, landless people, they can also be a local if Gram Sabha says so. Okay, if they are identified by the Gram Sabha, so decentralization is also there in the bill. Moving ahead, now there is a precedent with respect to the reservation policy here. The Tamil Nadu backward classes, scheduled castes and scheduled tribes. Reservation of seats in educational institutions and appointments of posts in the service under the State Act of 1993 says that 69% of the reservation is there for government jobs and colleges in Tamil Nadu, which ran into problems with the judiciary in 2007 and earlier as well. So what happened? Then Chief Minister Jayalalitha, along with the coalition of other parties, she led a delegation to New Delhi to meet the then Prime Minister P.V. Narasimha Rao, and then it was included in the 9th schedule. Now, if we talk about the judiciary, let's talk about that. Is 9th schedule really extremely, beyond the reach of the judiciary? It's not so. While the 9th schedule provides the law with a safe harbor from the judicial review, there are certain facts here. The protection is not blanket. The RI Although this law cannot be challenged on the grounds of the violation of fundamental rights, but they can be challenged on the grounds of the violation of the basic structure of the Indian Constitution, which was stated in 1973 in the 𝐾𝐫𝐤𝐬𝐴 Bharti case, if you remember. The basic structure test, if it is, failing the test, then it can be challenged. All right. Now, from here only, we can take the fact of basic structure. We do not have any, you can say the description of basic structure in any of our documents. Specifically, if we talk about the Constitution, it's not there. As an idea, we can say it was introduced by Justice Mudholkar in the Sajjan Singh case of 1965, who referred to a case from Pakistan judiciary of 1963. There are certain points that you can remember which are stated as the basic structure of our constitution, such as supremacy of the constitution, rule of law, independence of the judiciary, doctrine of separation of powers, that is federalism, sovereign democratic republic India should be, also the parliamentary system of the government should be, and principle of free and fair election, welfare state. And an example of the application of basic structure in the S.R. Bommai case of 1994 was also seen, in which the court upheld the Precedents decision to, dismantle the BJP governments in various places after the demolition of the Babri Masjid, because it was a threat to secularism. All right. Now let's move on and talk about the way forward. Although certain welfare benefits can be seen in the best interests of the locals, but it cannot be closed to judicial scrutiny. It can be open to judicial scrutiny. Okay. And any loopholes or shortcomings in the policy should be first discussed properly with the stakeholders, and then it can be moved along so that policy implementation does not have a problem in the later stages. Now let's talk about our question. Consider the following statements with respect to the 9th schedule of the Indian Constitution. Article 31B also has retrospective operation. The first amendment added 13 laws to the schedule. So we have to select the correct answer. That's it. Thank you so much for watching.